Sir, would you state your full name and spell your last name for the record?
My name is Glenn Palmer. Last name spelling is Palmer.
And you've been designated to testify today on behalf of the Grant County Sheriff's Office, correct?
Yes.
Sir, I'm handing you what's been marked as Exhibit 29. I'd ask you to turn to Exhibit A to that document, which is the Notice of Deposition of the Grant County Sheriff's Office. What topics have you been designated to testify about today?
According to Exhibit A, there's number 1 through 8.
Yes. Are you the witness that's been designated to testify about all of those topics on Exhibit A?
As far as I know.
What is other than your attorney, have you discussed this deposition with anyone?
No, sir.
What have you done to prepare for today's deposition?
Absolutely nothing.
And you understand that you're under oath, correct?
Yes, I do.
Okay. And you understand that the Grant County Sheriff's Office is a public body that's distinct from you as the sheriff, correct?
Correct.
And do you understand that the Grant County Sheriff's Office has a duty independent of you personally to respond to public records requests?
Yes.
Who at the Sheriff's Office is responsible for responding to public records requests on behalf of the office?
It would be me.
And have you had that responsibility continuously since you were sheriff?
Yes.
Have you ever delegated that responsibility to anyone else?
No.
Now, you have previously been deposed in this case in your capacity as sheriff, correct?
Correct.
And do you recall during that deposition, which occurred yesterday, that I asked you a series of questions about the policies and procedures that you followed as sheriff with respect to public records requests?
I believe so. Vaguely.
Is the Grant County Sheriff's Office understanding of what constitutes a public record different at all from what you testified to yesterday in your capacity as sheriff?
No.
Is the Grant County Sheriff's Office, how about can I use a shorthand? Can I just say the offices rather than Grant County Sheriff's Office, and we understand what I mean?
That's fine.
Okay. If you have any questions or clarification, please let me know. Is the office's understanding of its obligation with respect to public records requests in any way different from what you explained your understanding to be in your capacity as sheriff yesterday?
Objective form.
I'm sorry?
I just said objective form, but you can answer.
Yeah, I don't believe it's any different than my testimony yesterday.
Does the sheriff's office, have any written public records policies or procedures that have not already been produced in this case?
Not that I know of.
Does the sheriff's office have any policy, procedure, directive, or guidance, written or unwritten, that is related to the public records law and different from or in addition to any of the policies, procedures, directives, and guidances that we discussed in your testimony yesterday?
I don't believe there's anything any different than my testimony that I gave yesterday in relationship to the office. It would be the same.
Did you personally supervise the sheriff's office's response to any public records requests from the media to that office?
In all time periods?
Since November 1st, 2015, thank you.
Ask your question again, please.
Sorry.
It confused me as well.
Since November 1st, 2015, did you personally supervise the sheriff's office's response to any public records requests from the media?
Yes.
Was there anyone else within the sheriff's office that was responsible for responding to public records requests from the media during that period of time?
Not that I recall. Can I clarify?
Of course.
Other than asking for help from Sally DeFord to help locate some of those records and give them to me to disseminate them to my attorneys or as a public record, that would have been the only one that I know of that would have helped or assisted in gathering the data.
Do you recall ever asking Mr. Mobley to help in responding to any of the public records requests from the Oregonian?
The only one I can answer to that, I believe, is on the Coich case because he was directly involved in that. There's possibility if that was part of one of the public records requests, I would have asked him to look in his notebook. Best of my recollection, that would have been the only case, was the Coich case. He was directly involved with that one.
At any point in time since you were elected sheriff, did the sheriff's office attempt to train its staff on the requirements of the Oregon Public Records Law?
I want to say yes to a portion of it because I remember with Ms. DeFord, we actually looked at the Oregon administrative rule in regards to retention, and the closet that's in her office was starting to get pretty full, and we actually looked at the administrative rule in regards to what we could keep and what we needed to take over and archive in the basement of the courthouse and personnel files and people that no longer work there and haven't worked there for quite a number of years. And you know, that would have been the only, you know, we needed to find out what we could keep and what we could archive and what we could dispose of or
Okay.
get rid of according to the administrative rule.
Okay. Let me ask a couple follow-up questions. What documents were retained in the closet near where Ms. DeFord sat or Ms. DeFord's office?
We have all the backdated or outdated, I don't know if they're outdated, but previous case files from, I want to say, 2010, 2012, 2013, 2014, 2015. 2015s would actually be in a file cabinet out in the outer office, but everything else that's, as it goes, we move those out of the file cabinets and put them in cardboard boxes, and they're put down underneath the cabinets on the floor. They're too heavy to put on the wooden shelves, so those are kind of archived for public records requests or whoever may want to come back and look at a case that may come up later on in the years if we need to look at somebody or something else or go back and reinvestigate something.
Other than case files, were there any other records that were kept in that closet? I think you mentioned personnel files.
No, those are under lock and key in the file cabinet out in the main office right by Sally's desk. And you know what, I want to back up on your previous question because I want to make sure I get this up on the top shelf for a bunch of 3-ring binders that we don't have anywhere else to put them. So along the ceiling, we have a number of rather large 3-ring binders that we've investigated cases that's where those are kept as well. Some airplane crashes and homicides and stuff like that they get pretty in depth and they get too big to be putting in a normal case file like you have there. So we put them in a 3-ring binder and that's where we keep those. Those are in the closet as well.
So is it fair to say that the closet is devoted to records related to criminal cases?
Somewhat. There's other stuff in the closet as well. That's where it's kind of our central supply for evidence bags and evidence tape and drug test kits, tags, identification tags for tagging evidence, paper bags, hand sanitizer. There's a key box in there for all the vehicles. If anybody needs to go get in a vehicle, they can get into the key box. It's just kind of a storage closet for our central supply. There's notebooks and paper and
Got it. Okay.
Post-it notes and stuff like that in the closet.
Okay. And my understanding from your previous testimony is at some point in time you felt like the records in that closet were filling up, so you needed to determine if you could dispose of them or if they needed to go to the courthouse or other location. Is that right?
Correct.
Okay. And when was it that you made that determination?
You know what, it was a long time ago and it was just shortly after Sally took over because the person previous to her was not as astute at keeping things neat and organized like Sally does. And a little more organized, a little more professional, a little cleaner. And there was stuff that was there from the previous sheriff that we're running out of room and we don't have any other exterior storage area other than what's in the basement of the courthouse in a locked closet that the clerk's office maintains.
Okay, all right. So this was some years ago, right around the time?
Over 10 years ago.
Okay.
I'd say it was back around 2005.
Okay. And it was around the time that you kind of did this, what I'll call spring cleaning a little bit, that you reviewed the administrative rules to determine what records you could keep and what records could be disposed of. Is that right?
What could be archived, not disposed of. What needed to go over in the basement of the courthouse just to free up some of our area.
Okay.
And what we needed to keep and what we could get rid of.
Okay. Other than that instance, was there any other time when the sheriff's office made any attempt to train its staff regarding the Oregon Public Records Law and its requirements?
You know, I can remember talking to one of my past jail managers, Steve McGuire. There were some changes in the law in regards to switching our jail files over to an electronic format. Because also in that closet are the old jail register books. They're great big thick books that you like to see in the clerk's office where they enter their permanent record. They came up with some type of a statute that did away with putting it in that book, and the electronic format took the place of putting it into that book. So there was some training around that the staff did in regards to no longer having to take that extra step to put it into the book. But if you look back at those books, they're from the 1800s, and it's kind of neat to be able to physically look at them. And we still maintain those, but it's kind of a sad day that we quit doing that because it's kind of a history thing, and I'm kind of intrigued by that. But you know, I don't recall any formal training that we would fill out what's called an F6 with the police academy to get any kind of formally recognized hours for our training to where it count towards certification or, other than memos or, I can't think of any other training that,
Okay.
other than just briefings or just meetings with staff and say, this is what we're doing, or this is what the new law change is, and
Okay. You, does the sheriff's office have any policy or procedure in any format with respect to records retention and destruction that is in addition to or different from the policies and procedures that we discussed yesterday?
other than what's in administrative rule and what's in state law, I don't believe there's anything else that we would rely on to. I don't like duplication, so I wouldn't write a policy that verbatim was a state statute when we could go straight to the statute or to the administrative rule.
And you understand then as sheriff that the sheriff's office is a government agency subject to state statutes and regulations regarding document retention and destruction, correct?
Yes.
We talked, I asked some questions about the public records law, but I want to make sure that I ask this question as well. Did the sheriff's office attempt to train or discuss with its staff the document retention and destruction requirements in state law at any time other than what you talked about with respect to Mr. Ford or discussions that you just testified to?
Not that I recall. Not other than what I testified to earlier.
Now, both you and Mr. Ford have testified about two separate email addresses that are associated with your work at the sheriff's office, correct?
Yes.
Okay. You each have what we've been referring to as a Grant County email and a CentryTel email, correct?
Yes.
Does the sheriff's office have a policy or procedure instructing its staff which email to use at any given moment?
I don't believe so.
Does the sheriff's office have any, has it given any guidance on which of those emails to use other than relying on individual judgment at any given time?
I believe other than myself and Mr. Ford, everybody else has gone to the .gov account, because dealing with the public entity or the office of the sheriff being public, the .gov account is deemed to be more secure than the CenturyLink account, so everybody's kind of drifting that way. And as I testified yesterday, the only reason I keep the CenturyTel account is because it's published, and it would cost a lot of time and money to drop that account and get it published.
Who contracts with CenturyTel to maintain the CenturyTel email accounts that you and Mr. Ford have?
I believe the county court has that authority. They have the sole contract authority with our phone company.
Have you ever reviewed that contract since say 2010?
No, I don't believe I have.
Have you ever discussed what that contract provides? Let me start over. Have you ever discussed that contract with anyone since 2010?
Not that I recall.
Do you have any awareness or understanding about what that contract may say regarding the retention of emails within the CenturyTel accounts that you and Mr. Ford have?
Well, objection. He answered he hasn't reviewed the contract, so.
Do you have any understanding from any source, either a review of that contract, a discussion with someone, or your independent research of what that contract may contain?
I don't believe I was included in that discussion with the county court or the governing body.
Would you read my question back, please?
Do you have any understanding from any source, either review of the contract, a discussion with someone, or your independent research of what that contract may contain?
I don't believe so. And to clarify that just a little bit further, I don't know that they ever gave me a copy of that contract when they signed it. It may be on file with the county clerk.
Okay. Does the sheriff's office have a policy or procedure governing the retention of emails?
I'm going to advise you to exercise your right not to answer under Fifth Amendment privilege.
Are you the only witness who will be designated to testify on behalf of the sheriff's office, to your knowledge?
You can answer that.
On behalf of the sheriff's office, but not as individuals. I will be the only one testifying on behalf of the Grant County Sheriff's Office as we're being deposed right now.
Okay.
But under, that's okay.
That was my question.
Okay.
So you answered my question. Does the Grant County Sheriff's Office have a policy with respect to when emails may be deleted?
I'll advise you not to answer based on privilege.
Well, let me just make a record here. This is a deposition of the Grant County Sheriff's Office, which does not possess a Fifth Amendment privilege. To the extent that Sheriff Palmer is the only witness who will be designated to testify on behalf of that office and chooses to invoke the privilege, I'm reserving my right to either request that another witness be designated to testify on behalf of the office who may answer the questions that we have, or seek a adverse inference from the court with respect to the invocation of the privilege by Sheriff Palmer in this deposition.
And Sheriff Palmer's the only representative of the office that has the basis of knowledge to testify with respect to what is designated. And the fact that he's the only witness that can be designated under ORCP 39C6 doesn't require him to waive a privilege as to the Fifth Amendment rights that he has.
All right. have a different view on 39C6 and who may testify, but I think that's for a later day. I'll
Alright.
continue to.
Well, let me make a proposal to go off the record for a moment. I want to consider your questions and take some time to think about that,
Okay.
if you don't mind.
No, that's.
Then we'll resume.
Do you want to? Let's go off the record for a second.
We're gonna go off the record. The time is approximately 10:35. We're going back on the record. The time is approximately 10:43.
And for the record, I'll just ask Mr. Daniels to re-ask the questions.
Yes.
Hold on 1 second, I'm sorry.
Sheriff Palmer, does the sheriff's office have a policy or procedure with respect to the retention of emails?
No,
Does the sheriff's office have a policy or procedure with respect to when emails may be deleted?
no,
Has the sheriff's office ever instructed its employees to retain or preserve emails?
I want to say yes,
Why is it that you want to say yes?
because since this litigation started, I have talked to Sally DeFord about anything to do with this case. We need to make sure we preserve any documents or records that come in related to this case, and so there was that. But as far as other records for business for the sheriff's office, there's been no instruction for. I think it's just general knowledge that if somebody has something that comes in with a case or a case file or during a criminal investigation, and they get something that comes across on either the internet or via an email or communication from somebody, a text message on their phone that's sensitive to the case or it's related to the case, then those are preserved and also put into the case file as part of their investigation. So.
Other than communications or records related to a case or case file, has the sheriff's office instructed its employees when and how emails must be preserved?
Objective form. But if you can answer it, go ahead.
I don't believe so.
Has the sheriff's office ever instructed its employees when emails may be deleted?
I don't believe so. I've never had a discussion with anybody to that effect.
How is it that sheriff's office employees would know what emails they must retain and what emails they can delete?
Objection that calls for interpreting what someone else in the office knows, which was not noted as one of the deposition questions.
I'll withdraw the question. Did the sheriff's office direct its employees to follow any practice or procedure with respect to printing hard copies of emails?
No.
Did the sheriff's office provide its employees with any criteria or guidance that they would use when determining whether an email needed to be printed and when it could be deleted?
No, I don't believe so.
To the extent emails were printed by an employee of the sheriff's office, did the sheriff's office instruct its employees what to do with those hard copy emails?
Say that again, please.
To the extent that emails were printed by an employee of the sheriff's office, did the sheriff's office instruct its employees what must be done with those hard copy emails?
No, I think it's just common knowledge that when they print something off, that they've retained it for some reason, and it typically goes into a case file, or if it's part of an investigation.
If the email that was printed was not associated with an existing case file or investigation, did the sheriff's office have any policy or procedure regarding when files need to be created? Like a new manila file needed to be created?
No.
If a file needed to be created within the sheriff's office that was not a case file that Ms. DeFord had responsibility for creating, who was the individual responsible within the office for creating that file?
If it pertains to her work and her duties and responsibilities, it would be her.
What if it did not pertain to her work?
It would ultimately fall on me.
For example, you testified yesterday that one of the files that you have in your office is a file of, thank you cards and things like that from the public related to your duties as sheriff.
Mhm.
Do I recall that correctly?
Yes.
Okay. And were you the person who created that file?
I believe so.
And were you the person who determined what that file needed to be called or how it was labeled or identified?
Yeah, there's no markings or labels on it.
It's just a red well with stuff.
I call it an accordion file
Or
because of the
accordion
size of
file.
it, yeah.
Okay.
Yes.
And are you also the person who determines how the documents would be organized within that file?
Yes.
Does the sheriff's office have any policy or procedure requiring its employees to organize their emails electronically in any particular way?
I don't believe so.
Does the sheriff's office rely on the independent judgment and discretion of its employees to determine how to organize their emails electronically?
Yes.
What steps, if any, did the sheriff's office take to identify and compile the CenturyTel emails that were requested by the Oregonian?
Say that again, please.
Sure. What steps, if any, did the sheriff's office take to identify and compile the CenturyTel emails that had been requested by the Oregonian?
I'm gonna advise you not to answer based on Fifth Amendment privilege, because the record shows that the only steps that were taken were by Mr. Palmer.
Going back to the closet with the files that you testified to before, I want to make sure that I'm clear what happened and when. There was a point in time after Mr. Ford, right after Mr. Ford came on, when you and her decided to clean up that closet. Is that generally accurate?
I believe so,
And that was several years ago, correct?
quite a few years ago.
Okay. And in connection with performing that task, you reviewed administrative rules regarding document retention requirements, correct?
Yes,
Did you do something similar with respect to the files in that closet at any time after that initial clean out?
no,
I'm gonna object to the form of that question.
Do you recall what administrative rules you reviewed?
no, I don't have that I don't have that committed to memory.
It would be surprising if you did. um, Now, you testified yesterday that you have two cell phones, correct?
Yes,
Okay. And one is a personal cell phone and one is a county-issued cell phone, correct?
yes,
Does the sheriff's office have, well, I'm sorry, strike that. And I don't think I recall you testifying how long you've had each phone.
is that a question or a
Yeah.
statement?
It's a statement with a question mark at the end.
Okay.
How long have you had each phone?
I would say that I've had the 1493, which is my work cell, for, I'm kind of guessing here, maybe a year and a half. Without looking at the contract, I don't recall the exact date, maybe a couple of years. The 2420 phone was a flip phone until about March or April of this year. And I went to a smartphone. So,
What is the sheriff's office policy, if any, with respect to cell phone usage by its employees?
I don't believe we have a written policy as regards to cell phones.
Do you have an unwritten policy?
They should be used for official business only. But then again, not all my deputies have agency-issued cell phones. Some of them are using their personal cell phones while they're at work, so.
And is that a policy or understanding that you have communicated to them in your capacity as sheriff?
The ones that have agency-issued cell phones, yes.
And is that a policy that you deem applicable to you as sheriff?
Yes.
And has that been the policy or understanding that you've attempted to follow since you were elected to sheriff?
I'm gonna say no because back in 2000 when I was elected, I didn't own a cell phone up until just a few years ago,
Okay,
up to a couple of years ago, so I would say no.
okay. Sheriff Palmer, you've been handed mark as Exhibit 30. This is a document dated April 14th, 2016. Do you see that?
Yes,
And this document is a public records request, and it looks like it was received in the Grant County Sheriff's Office on April 15th, 2016. Do you see that?
say that again, please.
I'm sorry, do you see the received stamp at the upper right corner of the document?
Yes,
And does that indicate that the Sheriff's Office received this document on or around April 15th of 2016?
yes,
And is that your handwriting on the left side of the document?
yes,
Do you see that there's a request for documents related to the arrest, the investigation arrest of Mr. Willingham, request number 4?
okay,
And do you see there's a notation next to that dated April 15th, 2016, and it indicates active case?
yes,
And you wrote that, correct?
yes, I did.
Okay. And what was your intent in writing active case? What did that mean?
I'm going to object. This is not noticed in the deposition for the sheriff's office as to what Sheriff Palmer did. You did his deposition yesterday.
Well, let's take a look at the notice. It is the 5th claim. The notice, the first and second topics in the notice relate to the claims in the complaint. This is a request that's made to the Grant County Sheriff's Office, and I presume that Sheriff Palmer was responding on behalf of the Sheriff's Office.
Well, Counsel, you've sort of gone back and forth as between the issues raised in your 39C6 as just the policies and how the Sheriff's Office has any policies with respect to responding to public records. And now you're going into what Sheriff Palmer did personally.
Well, let me clarify my questions then,
All
and
right.
then we'll see if we can get there a different way. I would note that the first topic is the allegations and the factual basis thereof contained in the First Amendment complaint, and I am asking about records we requested in the 5th claim.
Okay. Well, I want to make this as efficient as possible, but and so I'll note my objection. But let's continue.
Okay. Well, let me ask my questions in a different way. This request from April 14th, 2016, you see it was directed to the records custodian of the Grant County Sheriff's Office, correct?
Yes,
Okay. And is there anyone within the Sheriff's Office other than yourself who would be responsible for responding to this request on behalf of the Sheriff's Office?
no,
And when you responded to this request with these handwritten notations, your response was, at least in part, on behalf of the Sheriff's Office, correct?
yes,
And the reason for that is this request was directed toward the Sheriff's Office, correct?
I believe so.
And when you were responding to the 4th request regarding Mr. Willingham, were you responding on behalf of the Sheriff's Office?
Yes.
And when you responded on behalf of the sheriff's office to that request by noting active case, what did you mean in that response?
As far as I can recall, the federal government came and got Mr. Willingham and took him to another facility somewhere in the state. I went and talked to the district attorney, and he told me not to release anything because it was still an active case.
Are you aware that subsequently it was determined by your attorneys that the case was no longer active and records related to Mr. Willingham could be provided to the Oregonian?
And do you have a date of that, Councilman?
I don't right now. There's, let me confer with. I'll get that date in a second.
Okay. I think it'd just be helpful to get a record as to when Mr. Sheriff Palmer talked to the DA, and then when it was subsequently determined that that was no longer an active case.
That's fine. And to be clear, I'm not asserting in any way that the assertion of the exemption at that time was inappropriate.
Okay.
My questions are going to go to the scope of the records that were eventually released and if additional records exist.
Fair enough.
So while we're pulling that up, do you, what is the sheriff's office policy with respect to the use of body cameras in the course of an investigation or arrest?
Again, we rely on state law. I know we have a policy. I don't have it committed to memory, but if you're in possession of one and you get out on a call, if you're in possession of a camera and you begin an investigation, you're required to use it.
Do you, testifying on behalf of the sheriff's office, know whether any record exists of a recording from a body camera of an interview or arrest of Mr. Willingham?
Not that I recall.
Have you ever made an investigation or done a search to determine whether such a recording exists?
Not that I can recall.
If such a recording does exist, where would it be kept?
It would be typically kept in the case file, or it would have been made available for discovery with the district attorney.
I'm told that records related to the arrest of Mr. Willingham were provided on or around July 26th. Is the body camera recording, is it on a DVD or a CD, or how is it maintained?
The body camera.
Objection to the form. I don't know if the question meant to assume that there is a body cam of Willingham, but
That's a good point. Let me rephrase. In general, if a body camera recording is made of a suspect, it doesn't have to be Mr. Willingham, how is that recording maintained in the case file?
It's on a CD.
Okay.
Or a DVD.
And sitting here today, do you know one way or the other whether a CD exists in the case file associated with the March 2016 investigation or arrest of Mr. Willingham?
Not without looking at the file. I don't have anything committed to memory on that.
Does the sheriff's office have any type of policy or procedure with respect to requests or applications to be deputized that would have applied to Mr. Casuccio?
Not other than what's given to me in my authority as the sheriff to deputize or undeputize as I see fit. And that relates to volunteers, non-paid staff.
Does the sheriff's office require the creation and retention of any records related to special deputies other than the document that appears at Exhibit 31? I'm sorry, or 31, yes.
No.
And I'll object to the form of the question.
Take 5 minutes.
We're gonna go off the record. The time is approximately 11:09. We're going back on the record. The time is approximately 11:13.
Just a few more questions. With respect to the cell phone records from your personal cell phone that we discussed yesterday, was there anyone within the sheriff's office, specifically Mr. Ford, who assisted you in identifying the caller information on those records from the 2420 number?
I don't believe there was, no.
And you testified earlier that the policy with respect to county-issued cell phones is to use those for work-related purposes, correct?
Yes.
If the records from your county-issued cell phone reflect calls to and from an individual named Jim Angel, or Angle, is it fair to assume then that those relate to your work as sheriff?
I think it would be fair to answer it could go either way. It could be work or personal. I can't control who calls me on my work or my personal cell phone.
What would, in your mind, be the determining factor whether the conversation related to your work or was personal?
And again, the same objection is that this ground was covered in Mr. Palmer's deposition yesterday. This is for the organization.
I'll withdraw the question. No further questions. Thank you.
This concludes the video deposition of Grant County Sheriff's Office, consisting of one videotape. The time is approximately 11:15 a.m. The original tapes of today's testimony will remain in the custody of Bridges Reporting and Legal Video Inc. We are now off the record.